Okay, so we're going to start. Welcome, everybody. For those of you who don't know me, my name is Barbara Mennel, and I'm the Rothman Chair and the Director of the Center for the Humanities in the Public Sphere in the College of Liberal Arts and Sciences at the University of Florida. And today you are attending the second speaker of our 2022-23 annual speaker series that's entitled Public Humanities. It is part of a multi-year series on the topic Rethinking the Public Sphere, which takes up the title of our Humanities Center. This year, we present speakers who engage with the humanities in the public. And I just want to list and appreciate our sponsors. So our series has been supported by the Margaret and Robert Rothman Endowment, the African American Studies Program, the Bob Graham Center for Public Service, the Center for Arts, Migration and Entrepreneurship, the Cotton Club Museum and Cultural Center, the Departments of History, Philosophy, Political Science, and of Urban and Regional Planning, the Rothman Family Chair in the Humanities, Jack Davis, and the UF College of Journalism and Communications Fund for Environmental Journalism, as well as UF Research. We'll have one more speaker in the series, and that is on Thursday, January 26th at 5 p.m. by Nicholas Allen, the Baldwin Professor of Humanities in the Department of English at the University of Georgia and the Director of the Wilson Center for Humanities and Art, and he will speak on public humanities as environmental humanities also in this room. If you're interested in our programming in general, please, and this, we also have programming dedicated particularly to undergrads and to graduate students. So please sign up either for our newsletter by adding your name to the list or using the QR code so that you get updates for the next events. And today, Barry Lam will present a lecture for about 40 minutes, and then we open for questions and answers. And we do have mics for the Q&A, and we have 2 mic runners, and we'll switch out the heading of the mic so that you have a fresh one. So we'll call on you and then you can have a mic. So I will now introduce our speaker for today, Professor Barry Lam. Just moved from Vassar College to the University of California, Riverside. He has received his PhD in philosophy from Princeton University, and he did his early career research in epistemology and in the philosophy of language. In recent years, he has turned to philosophy that is connected to moral, political, or public policy issues. In addition to traditional publishing in peer-reviewed journals, he's also interested in public-facing work through different media, including books, social media, and podcasting. He produces and hosts the successful podcast Hi-Phi Nation, a show about philosophy that turns stories into ideas. In that context, he also offers workshops on podcasts, particularly for philosophers, professors, and higher ed media producers. For his podcast, he has received support from the Whiting Foundation, the National Endowment for the Humanities Writ Large Fellowship, the Francis Ferguson Technology Fund, the Eleanor Neame Spring Fund, and the Templeton Foundation. He also started to work in philanthropy as an associate director of the Marc Sanders Foundation. So please now help me welcome Barry Lam.
Okay, testing, this is on. Great. Lauren, is there a way to lower the lights for the, okay, great, perfect. All right, thank you very much. I'm going to today talk about this issue of discretion, particularly in criminal law, but it applies more generally. For those of you who are interested about this topic in criminal law, how do I advance some slides here? Is this on? Yep. Okay. I did an entire season of my show, season 4, on issues in criminal justice, and in season 3 as well. That was a common theme, was what I was interested in at the time, still am. So if you're interested in some of this, a lot of these topics come up in the context of that season, particularly the episode on police discretion, but also on judicial discretion. The kind of discretion I want to talk about is the kind that people who are in enforcement or otherwise interpretation of the law, judges, cops, prosecutors have to do one of two things discretionarily. One is completely ignore a law that's on the books that they are supposed to be enforcing. And the other thing is less talked about, but also a prominent part of the job is interpreting law. So you might have a law that's vaguely worded, and a prosecutor from one kind of political bent might interpret it one way, and a prosecutor on another political bent interprets it another way. Let me start off by a story that I always begin every episode with something that happens in the world. I've been following police and prosecutors and judges for the last year or so. This is a story from Officer Mike, who patrols near where I used to live, Dutchess County, New York. There's an area of Dutchess County called Dover Plains. It's a very impoverished area. And even within that area, there's a place called Onion Town. Onion Town has a notorious reputation that goes back to the 60s. If you look it up, if you Google it, you'll see that Vice actually did a study of Onion Town because of its reputation. What is Onion Town? Onion Town is essentially a property that has a bunch of trailers on it illegally, and people squat there. The owner of Onion Town just lets it happen. And it's a deeply impoverished little section. It's just a turnoff off the side of the road. On top of Onion Town, the trailers don't have doors, don't have windows. The poverty there runs very, very deep. And there's a reputation, and this is actually true. If you drive up to Onion Town and you're an outsider and they don't recognize you, there's a row of bricks and rocks and branches that they will throw down at the car to try to prevent them from coming up. So Officer Mike was patrolling around Onion Town and gets a call from a store owner, convenience store owner, and said, someone just shoplifted from me. I know the kid. I know who he is. He lives in Onion Town. I want you to arrest him. Officer Mike is new at this time. So he's sitting with his partner. Officer Tom was there to train him and says, yeah, you know what? I'm good with the people of Onion Town. So like, they'll let me up. So he drives up to the top of Onion Town, and right there, you could see one of the big trailers. That belongs to the most personable person of Onion Town. They call them the mayor of Onion Town. So if you want to see anybody in Onion Town, you're required to knock on the door of the mayor. So they go up, they knock on the door of the mayor, and they said, okay, we need to see so-and-so. I think his name was Joey from Onion Town. We have a call that he shoplifted. Store owner said he stole a bag of white bread, a jar of peanut butter, and a gallon of milk. And he says, okay, I'll take care of it. Come back in an hour. They leave, they come back in an hour. Joey's sitting right there. And Joey says, yes, I know. I shoplifted, I admit it. What did you take? And he says, I took a loaf of bread, jar of peanut butter, a gallon of milk. And he says, I'll go to jail, but here's the story. I have a 4-year-old brother, and we haven't eaten in a week. So my mom told me to go down and get some food. And we don't have any money. So that's what I took. And she made us peanut butter sandwiches. They ate the whole loaf of bread. They drank the gallon of milk. It's gone now. And he says, well, you got a really angry store owner down there. He says, why don't you, he says, I'll go to jail, just arrest me. He says, let's see what we can do. They drive down to the convenience store. The store owner comes out and he's angry, and he sees the Joey in the seat, because that's the guy. And I'm tired of these people coming into my store and shoplifting, and you got right, and nothing you do prevents it. I want you to arrest him. And he says, listen, Officer Tom, is there anything we can do? The story is that he has a 4-year-old brother who hadn't eaten for a week. He stole exactly what you told us he stole, so he's not lying to us. And we feel like arresting this kid isn't going to do any good. So is there something that he can do for you, like clean the windows or sweep up the cigarette butts from the driveway and so forth? And it took about 10 minutes of convincing, because the store owner was very angry. He says, okay, go right ahead. So Joey gets out, they leave, they come back 2 hours later. Store owner comes out and says, listen, I apologize. I was very angry. This is not the first time this has happened, but this kid is a very good worker. And he said, well, how much was the loaf of bread and so forth? He says, oh, $6.27, something like that. He says, okay, and he's worked for you for a couple of hours now, so you've made that back. So anytime in the future where he needs food, can he come back and can he work at your store? He says, absolutely, right? Okay, this story, I want to highlight a few things. Cops are law enforcement, but actually no law was enforced in the sense of using force, right, to engage somebody who has broken the law. So using force, I mean just putting on handcuffs, putting them in jail, or anything of the kind. Number two, there was a social conflict that arose between the store owner and Joey, and that was resolved. It was brokered, right? There was a brokering of an arrangement that resolved the social conflict. In the background was an exercise of power. Yes, it was the power to be able to arrest. It was the power of having guns. It was the power of being the officers that allowed them to be in a position to broker that. Number four, there was nothing illegal about the arrangement. That is, the cops did in fact ignore a shoplifting law that was on the books by failing to arrest Joey. But there was nothing, no legal act could be held against the officer. You couldn't sue them or have some other cops investigate them for an illegal act, right? And I submit, I think, and I think a lot of you would agree, that this was a good case of policing. This was not a bad case of policing. And I think that's important, right? What's important is that we've recognized a good case of policing as a failure to enforce a law, right? But rather, a good case of policing was to broker a social, an arrangement in a social conflict that didn't require you to use force. That's a case of discretion, police discretion. Compare that to this story that, do you guys know what images I'm presenting here? So this is Les Miserables, the movie, and this story is as old as time, right? Like we use it in philosophy, not even pre-philosophy. We say, stealing is wrong, but what about if you're starving? And we use the example, loaf of bread. And of course you have Jean Valjean, who is standing right there, who was in prison for 16 years for stealing a loaf of bread, right? And then in Les Mis, you have this other officer, Javert, right? Javert, who is the opposite of Officer Mike, right? Out of principle, if a law has been broken, there must be some kind of state-imposed punishment consequences for that, right? And it doesn't matter if you were starving or whatever, or what reasons you had behind it, right? Law is the law, principle, rule of law. Talk about that in a second. So just to give a little bit of a definition, for any law, so this is a truth about at least US policing. It might not be true in other countries. For any law for which there is sufficient evidence to an officer, and that means probable cause, that's a very specific technical term, to an officer that it's been broken, whether to enforce that law against that individual is a discretionary and not a legally mandatory act. And what I mean by that is for any law, if an officer witnesses a murder right in front of them, it's still a discretionary act of enforcement. And I think you see no better example of that than in Uvalde, right? There was a lot of things can happen to those officers who fail to act in Uvalde, but they cannot be arrested for failing to intervene in the right way using force, right? So it's still a discretionary act. We live in a country where whenever an officer says, you give me no choice but to arrest you, that's false. They always have a choice that's built into the system. Right? It's up to the officer whether to enforce that. And this goes up the chain and across the branches, except for the legislative branch. That's the other branch, right? So from prosecutors to presidents, whether to enforce a rule or a law is a discretionary act. So one prosecutor I followed in Maine, Natasha Irving, refuses to enforce drug trafficking in her district. So much so that the attorney general says, okay, I'm going to have to take those cases. And she believes that it's immoral to enforce drug trafficking in her district. She can, if she wants to. Attorney general would prefer not to do it at the state level, but she refuses to. Steve Descano in Fairfax, Virginia, and 9 other prosecutors in Virginia after Dobbs' decision wrote open op-eds saying any law that Virginia passes criminalizing abortion providers or women, we will not prosecute, right? And you can just do that because you're a prosecutor and you have full discretion over which laws you enforce. President Obama, a big discussion came up with this with DACA, right? So President Obama decided that Dreamers were not going to be deported. In fact, register with us and we'll put you on a path. And I'm going to do it without a law, because the law actually says, right, doesn't distinguish between dreamers and non-dreamers. Okay, so discretionary law enforcement means there's no legal mandate forcing enforcers to enforce or enforce in a certain way. Okay, now the rest of the talk is about whether discretion is good or bad. And that's a complicated question because there are for particular discretionary decisions, both at the individual level and at the city level or the state level, the answers are, well, there are some good ones and there's some bad ones, right? So Officer Mike, I think we would all think that that was a good case of discretionary law enforcement, and Uvalde was a bad case of discretionary law enforcement. Those of you who have been to both New York and Los Angeles, I don't know what it was here in Gainesville, Florida, but you may know that in New York, jaywalking is almost never enforced, right? And if you go to Los Angeles and you see everybody like standing right here when there's no cars around looking at the red light, you'll know that in LA, they're scared to death of jaywalking tickets, right? Because it's always enforced. And so whenever I go to another state, I always like just look around, right? Are people just like, and here it's kind of in between, I noticed, right? So like some people, like I actually saw a few and then I just said, okay, I guess it's like that. And I just ran across, but then I noticed about like 10 others didn't just cross the street. So it's probably more LA here than it is New York. Is that correct? I just go by the norms. For the good case, you have like Natasha Irving, for those of you who don't like the drug war and drug trafficking prosecutions. And in bad cases, you have, prosecutors who want to, harass LGBTQ people by finding some old sodomy law that's still on the books. Even though there was a Supreme Court decision, it's on the books. They can use it to harass you if you want. You wouldn't get charged and prosecuted, but they can scare you with it. They can get somebody to arrest you for it. And that's happened in certain cases. So the answer is that some discretionary decisions are good and some discretionary decisions are bad. And if you're Socrates, you're going to say, well, I didn't ask you about cases of like, I didn't ask you for some good and some bad. I'm asking you about like discretion as a whole. So let's talk about that. So there are a few, if you want to look at this empirically, and that's how I'm going to start before I look at it philosophically. If you want to look at it empirically, there are a few natural experiments. And what I mean by natural experiments is a case where there was discretion, and then in the world, the same people did not have discretion. And then you could see like what the comparative outcomes were. And lucky for us, the 80s happened and the 90s happened. And those are a couple examples in the 80s and 90s where discretion was removed from police and also judges, and then restored in some cases. And then you could actually look at what the outcomes were. And it's complicated. So one of the things I want to talk about very briefly, it's a 40-minute talk, not a 50-minute talk. So I'm going to whistle through this very quickly. Lawrence Sherman is a very famous criminologist, and he was given an opportunity to do something that's entirely unethical from a research perspective now, but he was able to do it in 1984, which was on domestic violence calls. What happened was, what you want to happen is you want the officer to go to the location and you want them to be able to suss it out and think, what's the best thing to do here? Is this an arrest situation? Is this a situation where after I talk it out, they'll be okay? Or is this a situation in which I have to ask one of the parties to leave for 24 hours or 48 hours? Those are the one of three things that they did. And the officers did that on a discretionary basis as a judgment call. So what he wanted to measure the specific outcomes, right? But in order to do that and get any information, you can't have it on their discretion. You got to randomly assign. So like if a call comes in, just like pick a number pick a color out of a hat randomly, and then you're going to arrest, and you're going to do like mediation, and you're going to leave for 24 hours. And he was allowed to do that in 1984. And there were 314 domestic violence calls randomly assigned to one of three. And what he found at the time, only in Minneapolis, was that in the arrest group within 6 months, 10% were rearrested. within 6 months for domestic violence. In the group where the cops mediated, 18% were rearrested. And in the group where they made the perpetrator leave for 24 hours, it was 20%. Okay, so that was the very first study he did. And on the basis of this study, the press had a wonderful day and released it in the New York Times section, and it was reprinted. And the Justice Department called and said, do you know what we need to do? We need to pass mandatory arrest policies for domestic violence. And that's what happened. There was a social and political context in the 80s that made this very easy to pass. There was a left-right alliance about tough on crime on one case and violence against women on the other. Okay, so 28 states at the state level, and then many more municipalities at the local level passed mandatory arrest policies, which means that in this particular case, it meant something like up to a year in prison or a $1,000 fine for officers who fail to arrest in a domestic violence case, right? So discretion removed on a particular kind of call. There's a couple of things I want to note about this, this event. One was that it was democratic, and that's going to be important for later. It was democratic in the sense that it was a democratic elected legislature at the local or state level with wide support from the public at the time to pass that law. So it wasn't like a small minority rule kind of situation. That's one. And number two, these laws are still in effect in most of these states. They haven't been repealed. Okay. Same period, same year, 1984, Sentencing Reform Act. And this was an act that did some very long-lasting things in the judiciary. So it introduced the concept of a mandatory minimum. Do you all know what that is, right? So mandatory minimum is if you're convicted of a certain crime that Congress has decided is one of the crimes that they want to put a mandatory minimum, then it says no judge can give you less than 10 years, 15 years, 25 years, and so forth. There's mandatory minimums at the state level also. It also made sentencing mandatory according to the guidelines of a book called the US Sentencing Commission's Guideline on something like that. There's a committee that meets every year that updates this book, right? And it's appointed, you know, and this book used to be used as a guideline, like no judge knows everything, right? So they look up this book and they say, oh, this is robbery at gunpoint or something. And they're like, okay, what is this? Right? And it says, oh, between this many and this many months. It made that not a guideline, but mandatory. So no judge can go outside of what the book said. And it also abolished federal parole. So if you think about what parole is, it's a discretionary act, right? That is, somebody comes before a group that doesn't have to let anybody out. You could be serving your sentence. And they're like, on our judgment, based on the evidence before us, do we think this person is deserving of early release, et cetera, et cetera? It abolished that. So 1984, for mandatory arrest policies and the Sentencing Reform Act, removed discretion from judges and from officers for that one kind of crime. And this was also a democratic act. Right? This was a large, overwhelming majorities in the legislatures passed the Sentencing Reform Act. There was a left-right alliance and so forth. Was that good or bad? Right? When you judged outcomes. What do you think? I mean, like, what do you think happened? Right? I think we all know what happened in recent American history. Well, we know that there are skyrocketing prison populations, highest growth being women. Now, if you think about why that's the case, the likelihood that a woman's going to be arrested is for domestic violence, right? That's going to be the likeliest crime because, well, first of all, it's the likeliest call that police officers get, period, right? That's just the likeliest thing. And number two, some percentage of that is going to be women perpetrators, right? And if you have a mandatory arrest policy, they're going to be arrested. We know that African-American men were the largest group as victims of the prison, the explosion of prisons, prison population. What is true is that disparities in sentencing by race, class, and region went down between 1984 and 2004. That's true, right? Empirically true. So it did what it was supposed to do. So the idea was like, we had some judges doing this and some judges doing that, and we can't have that. So like, let's have them all abide by the book. There's some disparities because the guidelines are within a range, but you know, it went down. One of the most interesting things about Lawrence Sherman is that he went back to all of this. He did a bunch of studies, by the way, between 1984 and 2014 when he did the 40-year retrospective study. And by the way, he found that mandatory arrest was terrible for other cities. And it was just like, and he never advocated for Minneapolis. I did a whole episode on this. It's called Gender Justice, episode 4 of season 4. But what he found when he went 40 years later, looking at all of the cities, that when he looked at the victims of domestic violence and compared the group whose partners were arrested versus the group whose partners were asked to leave versus the mediation, the group with partners who were arrested 40 years later had a 64% higher chance of being dead by the time that he looked at them, right? So premature death rates. And for African-American women, it was even higher. It was 100% higher. We can talk in the question and answer about why that's true, why that would have been the case. There's some speculation that we don't know why, right? But there are some, you know, hypotheses about why that's the case. So mandatory arrest was actually a tragic move for the prison population, but it was also tragic for the victims of domestic violence also. Mandatory sentencing, well, here's something interesting that happened. 1984 to 2004 was the era of mandatory sentencing and mandatory adherence to the guidelines. But in 2004, the Supreme Court overturned some aspects of the Sentencing Reform Act. So it became guidelines again. So since 2004, we've had many years of comparing, right, what usually the same judges do under the Sentencing Reform Act. And what do we find? We actually find that the average sentences overall are lighter when judges are given discretionary sentencing versus mandatory sentencing. But the disparity across judges is bigger. And we would expect that. Okay. So back to this question, is discretion good or bad? Well, again, it's the real world. That's not a thought experiment. Reigning in discretion gives you some good things and some bad things. And ultimately, it comes down to a question of like, what do you value more, right? You get less disparity, but harsher, right? And so forth. Okay, so now I'm going to turn into philosophy, which people give more high-handed, what we call in philosophy, a priori answers to this question rather than looking at just the results. And of course, the results are complicated. And there is a long tradition in political philosophy or moral thought that goes all the way back to like at least the Enlightenment, if not further, in the Western tradition that sees discretion as bad, essentially. And the objections are twofold. The first is that discretion threatens the rule of law. What is discretion? It's to have certain people who are in positions of power decide what laws are enforced or decide what happens to somebody after they break one. And you shouldn't run a society that way. It's unjust because the principle of rule of law, what's permissible or impermissible, or what qualifies you for a benefit or something like that, needs to be explicitly written. That writing has to have authority, and you have to be able as a citizen to predict on the basis of the language alone how you're going to be treated by the state and how other people are going to be treated by the state. That treatment needs to be fair and equal to all citizens, and not based on the whim of a person who might like you, but not you, or something like that. Discretion threatens democracy in that the laws in a democratic society ought to be treated as a reflection of the popular will. And if you have some people in power who decide, this is the complaint about DACA and Obama given by Republicans, to give enforcers and bureaucrats the power not to enforce the law is giving parts of your government a veto power over democratically passed laws. That's the view from Western political thought of a certain tradition. But given that, there's been this acknowledgement that discretion is a necessary evil. It's an evil, but it's a necessary evil because of certain limitations. Limitations that today, some people who are tech optimists think we can overcome, but I'll talk about what those are. The limitations are language, technology, and economics. So let me give you an example. So here's a law. This, to my knowledge, is still the basic speed law of California. I don't know if it's the basic speed law of Florida. Anybody who's taken a Florida driving test, will they be able to tell you? The law is never drive faster than it's safe for current conditions. Now, who just looking at that law thinks, I have a problem with a law like that? Yeah, do you? Like, what would be the problem?
I mean, if you criminalize every single person who's ever speeding, it's like, if you're arresting them, you end up with a huge prison population, or you need a much oversized police force.
Why? Because they just don't have to drive. People just, guys, just follow this law. Just don't drive faster than it's safe in current condition. Vague, good. That's the word I was looking for. It's vague, right? So the idea behind this law is that it's vague. And we don't like vague laws. And language, I'm sorry, is vague, right? So like, what is the alternative to this? Okay, 35 maximum in a business district. And you're like, well, that doesn't solve the problem. Is a business district? Is this a business district? Like there's 3 houses and a business. Not a business district, right? So no matter what, you're still gonna have vagueness. Technology. Even if you can overcome that particular problem, we don't have the means to be able to track everybody who's speeding, right? This is the typical argument people give for law enforcement discretion. So we set up speed traps on this part of the highway, but not others. That's not fair. Then people speed over. Yeah, it's not fair, but you know what? Necessary evil, right? It's an evil, but we have to do it because limitations of technology. And of course, economics is related to that, right? Like, yes, you could hire endless supply of cops to like stand on every single street every 500 feet or something like that. But we're not going to end up doing that. Incidentally, the reason why I think that like technology today actually can track everybody's speed. Like it happens. I mean, it's really easy. It's like one of the things, like in your location data, you know exactly how fast you're going at any given time. So like actually we can do it with technology now. I think you would be enraged by the state doing that, right? But the goal in this tradition is to temper the badness of discretion, limit it when it's possible, but always recognize that it's an evil. There's another tradition, 28 minutes, okay, good. There's another tradition that argues against discretion that comes from a completely different part of the world, a completely different time period. And that's the legalism tradition in Chinese philosophy. So this political philosopher Han Feizi made this argument, and it's funny how incredibly close this is to a lot of the way modern day bureaucrats think about this stuff. But Han Feizi argued like rulers or the people who are enforcing of laws, they're always going to be mediocre, right? Just as subjects are always mediocre. Neither will, in the face of things against their interest, enforce a law or follow a law contrary to those interests. So what you do is you have to impose a system of punishments and rewards for rulers and for individuals so that it is aligned with their interests to follow the law. And in the legal system for rulers, we should have the system and not individuals be the things that we rely on. That is, it shouldn't be up to having a good officer, Mike, right, to do the good thing and a bad officer, someone else, to have arrested Joey. So it shouldn't be individuals, but rules, right? So that you can replace the individuals everywhere, and they're just abiding by the rules set forward by them. And so one example of this kind of argument is like the argument against judicial discretion, right? Judges are mediocre, you might say. They might sentence harshly because they're hungry and it's 11:45, which there was a study that actually looked, the average sentence was higher when it was 11:45 a.m. Why is that? Well, because they're judges and they're people and they get hungry and grumpy. We can't leave justice up to things like that. So it must be that for every job title, we write out all the things that they can do, all the things they can't do, line up all the punishment, and if they deviate from it, they're automatically overruled. I mean, boom, mandatory sentencing and mandatory sentencing according to the guidelines. So for the rest of the talk, I'm going to, I don't know how I think about this, but I'm going to start pushing back against that argument. So do a little bit of philosophy here, and then we'll see where you all fall on this question. And so what I want to suggest, and don't hold me too hard to this because I'm still figuring this out myself, is that maybe discretionary enforcement is not a necessary evil, but maybe it's a constitutive of a good society, right? And maybe that march toward legalism and the rule of law isn't. So contrary to both the Han-Fei's tradition and the tradition in Western philosophy. And I want to do that by looking at not discretion for rulers first, but discretion for like the subjects, us, the people in the society. And I'm going to use an example from my personal life. So I want to introduce you to Darcy, who's my 10-year-old. And Darcy has had the job ever since kindergarten of unloading the dishwasher. That's her job. Darcy is an arguer, right? So a lot of times it'll be a day, sometimes a day and a half before the dishwasher is unloaded. And being the kind of parents we are, we leave the dirty dishes stacked. I mean, we rinse them because you have to rinse them, right? And we say, Darcy, the dishes are stacked and we can't load it until you unload it, right? And sometimes we had a monetary reward and she argues, right? And so this is a very typical discussion with Darcy, which is the job is that I unload it. It doesn't say when, right? Okay, so then like, what's the natural response? I mean, besides, whatever, which is like, okay, so maybe the rule should be Darcy empties out the dishwasher within 5 hours of the completion of a cycle. Yeah, okay. But sometimes it takes an hour for Darcy to do it. Why? Because she gets distracted. But you never said how long it has to be. I started within 5 hours of it. So it's like within 10 minutes, right? So then the rule is not Darcy empties out the dishwasher, but within 5 hours of the completion of a cycle, within 10 minutes of starting it. But what if you run the cycle overnight? Very typical Darcy thing to say. And then when I wake up, I got to go to school. And then by the time I come home, it's more than 5 hours. Darcy empties out the dishwasher within 5 hours of the completion of a cycle, unless she has school or other pre-booked appointment, in which case she has 5 hours from the time of the booking appointment, and must complete the task within 10 minutes of starting it. But sometimes I have to go to the bathroom, and it's number 2. So it takes longer than 10 minutes. Unless you have a bathroom, okay, so what am I exhibiting with this? Which I think a lot of you who are older are familiar with. I call it the march to Byzantium, right? If you're involved in anything bureaucratic or at a state school like University of Florida, and I'm learning right now at the University of California, you recognize this kind of stuff. It used to be, go out to dinner, pay by credit card, submit the receipts, get a reimbursement, no alcohol. Receipts have to be itemized. Blah, 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 right? The march to Byzantium is the march to more and more arcane rules in response to someone like Darcy, right? Or whatever the equivalent of that is supposed to be. You see this in like sentencing guidelines. If you look at the sentencing guidelines, and it doesn't even come close to covering all the contingencies, but they try, right? So like robbery gets 6 months. That's a very simple rule, but it's like, okay, we have a gun problem. Oh, it's way more dangerous to rob with a gun. All right, robbery using a gun is like 12 months, but robbery is just 6 months. What counts as using, right? So like, what if like I like flash the gun, but I don't like take it out, right? Or what if like it's a fake gun? Is like a fake gun a gun? What if I like just stick my hand like that, but it's not a gun? Should that count as a gun or not a gun? What if the person believed that it was a gun? Okay, so you can see, you can start articulating more and more Byzantine sentencing rules that account for each one of these contingencies. Okay, and the march to Byzantium is just like a common feature of American life, and most definitely in American regulations and American rules, American criminal law, American sentencing, and so forth, right? And it's a feature of a lot of things. I don't want to simplify this, but it's definitely a feature of legislation by outrage and a legislation by anecdote, right? So when the legislature decides, I'm going to pass a bill, all right, and it's going to become a criminal law on a certain thing, and it's almost always in response to something in the news that's outrageous, right, or something like that. So, and I want to say it's democratic. So this is going to come back, right? And I think, I'm not sure about this, but I'm going to submit that we all agree that it's not good, right? It's not a good thing. Maybe it's a necessary thing, but it's not a good thing, right? Because, okay, on the one hand, rule of law, you're supposed to know exactly how you're going to be treated by the law by reading the statutes. But none of us fucking read the statute. We don't even read the thing on the credit card statement, right? And there's nothing criminal happening there, but we don't read it precisely because it's Byzantine, right? There are oppressive requirements of knowledge for individuals when you have a Byzantine legal system. If you have a legalist system like Hi-Phi wanted. We know that it leads to a surveillance state, right? Because in order to enforce things that are Byzantine, right, we need to know very precisely things that people do. So if you have speed laws like, right, in a business district, it's this, but if it's business district on a country road, it's this, right? That, right, we need a lot of surveillance mechanisms to know which of the contingencies. Okay, so there are a lot of these complaints about the march to Byzantium, but I want to submit that there's a deeper concern about this, and it's the following. Suppose I ran my household, or if you're young and you're living with roommates for the first time that are around your same age and you run into problems about who's doing chores and whatnot, right? If you were to run your household according to the things that lead you to Byzantium, this is a technical term in philosophy, you done messed up, right? You're doing something wrong, like that's just something wrong about the way you run. Like if it turned out that the way I ran my household was every single time Darcy like argued with me about a particular thing, I articulated more and more Byzantine laws. So by the end of it, for every chore, there's like every single exception. I've been raising my child wrong. Now what? Let's articulate why that is. Why do we think that that is something that you're doing that's incorrect, right? What you want is for her to internalize the reasons that she has to empty the dishwasher in a timely way. It's like she benefits from us dividing the chores up in a certain way, and that if you don't do it in a timely way, it's backed up. What you don't want her to do is to say, well, let me go into compliance mode. What do the rules say? Is it within 5 hours or not within 5 hours, right? And the same thing with your housemates or your roommates, right? You want them to internalize the reasons behind the rules, and you want them to cultivate the kind of judgment about those reasons to understand that, like, maybe you violated it, but you had a good reason, you were sick, and that shouldn't count against you or something like that. Similarly with like speeding laws, what you really want is people to cultivate a sense of when it's dangerous, right? Not if the sign says you can go 45, but it's icy. I guess it's never icy down here, but like it's icy in the Northeast, right? You want them to cultivate a sense of that so that they won't drive 45 on an icy road. Not, is there a law that says 45, not icy? Like icy, what's the law for an icy road? That is, okay, anyways. So translating this over to 39 minutes, good. Translating this over to rulers. The ruler who needs the Byzantine laws are not cultivating in their subject the appropriate judgment you want your subjects to have. Okay, now transfer this over to the ruler itself. A second, right? I think I just said this, right? The person who requires these rules is not making a good faith effort to learn why they exist, the purposes of them, right? And to cultivate judgment about when to follow them or not. You don't want a society filled with people who act solely for legal reasons. I mean, that's horrifying to me. I think that's true of rulers too, right? That's what I want to say. You don't want police, prosecutors, and judges to act as enforcers and judges of law for only legal reasons, right? You want them to cultivate judgments about justice outside of the guidelines of the law, right? You don't want them to be acting only because a legislature, even a democratic legislature, has passed a certain set of laws. I think that's true. I think I want to say that, right? And because of that, you don't want the restrictions on rulers to be Byzantine either, as you get with mandatory minimum sentencing and sentencing guidelines and so forth. Okay, so these are some of the, in the literature, some other defenses of discretion, not the one I just gave, but in the same spirit. Democratically passed laws are not always good laws. And one of the checks on them, not the only check, but one of the checks on them are enforcers who recognize that they're not always great laws, right? Don't think any of us fault officers for not enforcing Jim Crow. There weren't too many of them, but there were some. I don't think we want to fault Natasha Irving for failing to prosecute drug trafficking in her district, for those of us, right? Does it have a side effect? Yes, it does, right? Because with discretion comes good discretionary decisions and bad discretionary decisions. There will be some, I don't know, this is Florida, but there was like this idea that, oh, it's actually a good thing for sheriffs not to enforce masking indoors, but like in other states, we talked about how that was a bad thing, like because, right? But like whatever you think about that, that's a mixed kind of case, but some people think that was a bad thing. But that's going to be a side effect if you have discretionary enforcement. It's also true, I think, Hanfetze and people like Kant and Locke and all them were correct, is that enforcer discretion can lead to tyranny, right? And violations of the rule of law. And sometimes removing discretion is a check on that. But those things together, I think, is what's responsible for the march to Byzantium, right? Those things together. Mutual distrust of the subjects. They think you're all like my daughter Darcy, so that's why we got to keep passing more and more Byzantine laws. Mistrust of judges and officers. That's why we have to like make them do this and not make them do that, and so forth. Those two checks are what I think lead us to more and more Byzantine laws on both sides. And the result of removing discretion is that you get a society with something nobody wants, right? It's kind of like nobody wants the law run by, you don't want to be governed by Byzantine laws. Rulers don't want to be governed by Byzantine laws either. And the result is a society of surveillance and compliance, not a society of people cultivating wise judgment about what are the good moral reasons for ignoring a law or not. So that's my case for discretion. What do I have as a more promissory note on what I like as 4433? Okay, good. Here's what I'm a fan of. I actually like vague laws, right? I actually like never drive faster than it's safe, empty the dishwasher in a timely way. I even started doing it on like my paper assignments for students. Like, how long should this be? About 1,200, right? What is it, 2,000 to 25, or is it 1,200 limit? No, about that much, right? Why? I want them to cultivate the judgment. Like, do you really need that much more? If you think you need it, that's your judgment. It's up to me then to like mark, oh, you didn't need that, right? And like for judges, treat like cases as like and unlike cases as unlike. And like, Well, we don't like that because, well, I think what I like about vague laws is that it cultivates two-way discretion, right? It's discretion on the part of the subjects to have to cultivate the judgment on what that constitutes, and judgment on the side of the enforcers. Okay, so that's all I'm gonna say. I'll take questions and then we'll flesh it out, the abridged version of this talk, right?